Morning, everybody, and welcome to this webinar today, where we're going to be looking at the potential coverage gaps arising in the health tech space. My name's Sarah Rose, and I'm a Principal Associate in our insurance sector and part of the firm's medical malpractice team. And I'm joined today by my colleague, Amy Bell, who's a Senior Associate in the same department. Just a few housekeeping points before we get started. A reminder that this session is being recorded, and whilst you can see us, we can't see you. We are aiming to have time for a Q&A session at the end of the webinar, and if you do have any questions, please pop them in the Q&A box at the bottom of your screen, and my colleague and Senior Legal Advisor, Harriet Strevens, will pick them up for us at the end. If we do run out of time, please don't worry, we'll make sure we deal with them separately after the session by email. So as you can see on the slide, today's agenda will be addressing a number of aspects, including what health tech is, why we should care about it, where claims arise, and what that means for insurers and insureds alike. So without further ado, I'll hand over to Amy to set us off.
Thanks, Sarah. Now, the first question that some of you might have when you look at our topic today is what is actually meant by health tech? And that's a good question, as it can depend on who you ask. The World Health Organization, for example, states that health technology is the application of organized knowledge and skills in the form of devices, medicines, vaccines, procedures, and systems developed to solve a health problem and improve quality of life. But the definition from the Department of Health and Social Care is more wide-ranging and considers that it includes items we rely on every day, from a simple plaster for a scraped knee to life-saving blood tests that can detect cancer early and robots that perform highly complex surgeries. So whilst all digital health technologies can be classed as health tech, not all health tech equates to digital health. It covers a vast array of technology tools, which I don't intend to talk through everything today, but we will flag some of the areas which are gaining increasing prevalence in the sector and a more widespread uptake. So as you can see, in terms of clinical use, these can include using technology in direct clinical treatment, for example, medical devices that can diagnose and treat or monitor conditions, such as insulin pumps, which the user wears and automatically releases insulin doses so that patient-controlled injections or tablets are not required. It can also include general well-being and health apps, such as those we associate with fitness, which can take your baseline measurements and give you your health stats. Finally, on the more complex side of the scale, we have robotic surgery and the use of augmented reality in helping professionals in treatment and training. There is also a use for health information technology on the administrative side, such as electronic prescription ordering, patient portals, and remote healthcare or virtual appointments.
So why should we care? Well, the global digital health market is growing rapidly, and estimates of the UK share of the global market vary from $4.87 billion to $13 billion. It's said that there are 10 new digital health technologies brought to England every day, which equates to 4,000 per year. This area is seemingly only going in one direction, and therefore its likely potential exposure will grow alongside it. So how does this impact the insurance market? Well, to answer that question, it's necessary first to closely understand the risk. So where might claims arise? Well, as we've said, health tech is still an up-and-coming area. Although more progressed than, say, the interplay between generative AI and general professional services, its relative infancy means we don't have a wealth of case law to refer to yet. We therefore have to look at the potential risk for claims, which in our view are relatively widespread. The biggest potential areas as we see them are medical negligence or bodily injury. So this can include physical injury due to a product malfunction, for example, an over or underdose of insulin, taking Amy's earlier example, a misdiagnosis due to incorrect collection or processing of data, inappropriate prescribing. So say, for example, you have a patient who is waiting to undergo major surgery and needs to have some well-being support to perhaps lose weight. If they're inappropriately prescribed a weight loss app because unbeknown to the person suggesting it, they actually also suffer from an eating disorder, there's a real risk of unintentional harm. There's also the potential for poor risk policies, leading to potentially inappropriate patient contact or relationships. Regulatory issues are also important, and the regulation of health tech is far from straightforward. There's been an increasing focus on AI in particular as needing to be classified as a medical device and therefore fall within the rigors of the existing legislation. But there does remain a real regulatory grey area for many digital health initiatives in particular. One key example is those health apps. For technologies that are based on more backroom administrative processes, that's not necessarily incorrect. But there is a real need for clarity where caregivers are more routinely looking to prescribe or consider the use of health tech as part of their treatment plan for patients. And it's also important to think wider than bodily injury, technology failure, and consider the potential cyber or IP risks, for example. Take a systems failure or an attack on a live dose adjustment technology based on real-time monitoring, or a server outage which affects augmented reality as it's being used. Similarly, technology is often used internationally, and what would happen if users were based outside of a licensed jurisdiction? It's clear to us that there are a whole host of first and third party risks potentially at play here.
And in addition to where the claims may arise, it's also necessary to consider who the relevant parties to the litigation might be. Is a manufacturer or designer going to be held responsible for an injury caused as a result of inaccurate prescribing? Or could they be considered liable despite a third-party development of the app, which has been made to better suit the needs of that third-party organisation or client base? Could a clinic or hospital be responsible for a loss of data arising from an attack on that data over which they have no direct control? And could there be only a single type of harm arising, or is it feasible that multiple covers could be invoked? We can envisage situations, for example, where there's a risk of physical injury, but also data loss and reputational damage caused. No doubt there will be numerous contractual warranties, indemnities, and exclusions at play, but will that prevent claims if, for example, the court takes a more strict liability approach to ensure protection of a patient? Finally, we're watching with interest to see how the law of causation and contributory negligence, in particular, develop to tackle the complex contractual claims and issues arising. And so what does this all mean for the insurance industry? Well, the emerging problem for insurers and insureds alike is that there's a real risk that these technologies don't fit within the traditional medical malpractice or technology covers, owing to the common exclusions we tend to find in those. So generally, medical malpractice policies will include exclusions for and losses relating to a product or any failure of cyber program, electronic device, equipment, or system. Conversely, most technology policies will exclude liability for bodily injury, sickness, or death, unless they are directly arising from a breach of duty by the professional. And so there are a number of potential issues which we can see arising. Will the specific piece of technology engaged be considered a product as defined in the policy? Has the injury arisen directly as a result of the technology, or, for example, as a result of the inaccurate use of that technology by the professional? Are there in fact multiple policies triggered? And has the health tech company obtained any malpractice cover at all?
So if we take an example of an AI-assisted review of scans to detect cancer, if there was a failure in the technology leading to the misreading of the data and ultimately misdiagnosis, who is responding to that claim? Is it the treating clinician relying on the AI, the hospital or clinic that's mandated its use, the technology manufacturer? What if the error arose because of a cyber attack? Would a standard technology cover respond? This is an increasingly complex legal and regulatory landscape, and there's a high risk that those operating within the sphere could find themselves uninsured or, in an attempt to mitigate that risk, conversely overinsured. To understand this, insurers and insured clients need to be clear as to what it is exactly they are insuring, which can be difficult. An app developer is unlikely to be thinking about the end user and what insurance category any issues might fall into. Similarly, if the risk is not fully understood, insurers might not automatically be alive to the wider exposures such as IP disputes. For now, claims that do arise appear to be being dealt with on a rather ad hoc basis, but how long that's sustainable remains to be seen. And our own conversations with those leading the way in the health tech space is that the issue of insurance is keeping them awake at night. Our present feeling is that, much like the development of cyber coverage, the industry will watch to see what claims, if any, start to arise, and where necessary, look to adjust underwriting practices going forwards. Now, that may mean a wider adoption of more comprehensive policies, blurring existing product lines and allowing for no gap cover, or closely reviewing existing policies and adopting specific exclusions for health tech to prevent the blurring of lines. Insureds are also likely to be more alive to the risks and may well start reviewing policies to check they're not paying over the odds for cover that's not necessary. And no doubt that's a discussion brokers will be having going forwards. Our experience as a firm from discussions with colleagues who work closely with those startup companies entering this space is that although there is an awareness of the standard risks, the broader picture, and particularly issues such as cyber and IP exposure and the need to consider the varying uses the technology may be put to, is not always at the forefront of discussions. In terms of the impact on professional negligence claims, the message really is one of watch this space. It feels that it's only a matter of time until the claims start to arise. For now, it's in all parties to the insurance contract's interest to be alive to the potential risks and ensure good mitigation practices are in place. And we will certainly bring you any further updates as and when developments occur.
So, in conclusion, whilst there are many potential risk areas, we're not here today to say that insurers need to be panicking or preparing to open a blank checkbook. The risks are manageable, but in our view, some real thought needs to be given as to how this is best approached. Regulatory framework will no doubt have a major influence, as will insurers, insureds, and brokers developing a broader view on the specific risks that they're looking to insure. This is a new and pioneering area, which is exciting, but also brings its own challenges and may require a little bit of thinking outside the box in order to ensure that innovation continues to flourish. We'll now pass to Harriet for any questions.
Thank you very much indeed, Amy. We do have a couple of questions, so if I can direct this one to you, Sarah, first. Under the heading, why should we care? You mentioned that sources report as many as 10 new digital health technologies coming into the UK every day. Do we have any idea where they're coming from? Which country, what region? Or is it just random?
So I think it's fair to say that there's a big industry in the UK. We're very lucky that we are seen as a very innovative place, and health tech is really sort of on the rise there. So I think there's a lot from the UK, but we'd be amiss to ignore the fact that places such as the States are really driving this area, probably and likely because of the fact that their privatized healthcare means that they can sort of introduce these rollouts a lot more quickly than we can. So I think it's across the board, but we shouldn't turn sort of our attention away from the fact that the UK is a real player here and seen as a very attractive place for these companies to come.
Long may it last, we say.
Yeah.
You also talked about the risk associated with health tech, and you spoke about 3 potential areas. Can you explain what you actually mean when you said there is the potential for poor risk policies leading to potentially inappropriate patient contact relationships, with the emphasis, as far as I can tell, on the inappropriate patient contact and relationships?
Yeah, so that's really in terms of telehealth. So I think since the COVID pandemic, I'm sure we've all been familiar with seeing our GP virtually a lot more, or having virtual appointments offered to us. And obviously that was necessary during the pandemic, and it's necessary to continue to try and sort of clear the NHS backlog and to just help generally with access to care. But the issue is that if the incorrect appointment is put for those treatments, or if the incorrect technology is used, then you could end up with a situation where a patient is left without a chaperone where they need one, or exposed to a room that's actually not secure, or in the worst case scenario, sort of ending up with a consultation with somebody from another jurisdiction that isn't licensed. So it's just about the risk policies and the need to be very clear about what practice it's appropriate to use this health technology for. And when we can use it, it's fantastic, and we should definitely not shy away from that. But just being aware of the wider picture and making sure that all the appropriate risk policies are in place, as they would be if it was a physical sort of face-to-face consultation.
And presumably vulnerable people, and by that I mean people who are disadvantaged or have already recognised conditions, are at greater risk for those sorts of errors to occur, I suppose.
I think potentially, although you'd hope that they would be flagged and it would sort of be considered when they're putting them in. I think it's more just a general acknowledgement of making sure that risk policies reflect what the risks could be from the digital health and the kind of the health tech sphere, as opposed to the more traditional practices that we're used to.
Yeah. Amy, you were talking about who is the relevant party. You give several examples, including who might be in the firing line on a claim for loss of data over which they have no control. I appreciate there may not be a definitive answer to this, but it does beg the question, have you got an example of what constitutes having no control, for example?
The reference to no control in that sort of context was a third-party hack, for example, of the app or technology. And I mean, we're not saying that any situation like this is going to immediately put the designer or user in a responsible position. And if they've taken all the appropriate steps to ensure the data is protected appropriately, then they shouldn't be put in that position. But we're looking at, for example, does the app have appropriate protection included, and has that been utilized properly by the user? Or if the user's not followed all the steps to keep the data safe, but the app didn't have protection in line with the Act, is the developer responsible? There's various questions that arise. Also need to ensure that the patients are fully aware of how their data is being used and processed and stored. And so there's nothing really that we have a definitive answer for at the moment. They're all just questions that we need to consider going forward.
Yeah, I can see that.
Yeah.
And here's another one, and my last one. You were talking about what this means to the industry and the possible overlap between policies and what they're insuring.
Yeah.
Do you have any idea from your own perspective how you think the industry is going to deal with trying to get cover for all of these products when we're really in a very early stages of what's out there?
I mean, we've already seen sort of a couple of composite packages being offered, but I think, again, it's going to be something which depends on all various factors. So what cover does the insured already have, and can their additional needs be relatively easily added on to that cover for an increased premium, or do they need something sort of more bespoke that's got various different areas? And the appetite of the insurers is also going to influence that, because some that might not currently offer medical malpractice cover may be reluctant to move into that space and may prefer to stick to being a technology insurance provider, in which case they may well accept that some of their clients will move, but that's their choice. Whereas others will be more happy to expand their offering to whatever their client requires. And I don't imagine it's going to be a straight line to get to one end product. There's going to be some trial and error, and there's going to be various different products on the market, I imagine.
It's still very exciting. I'm sorry, Sarah, go.
No, sorry, Harry. I was just going to say, I think it will also depend on how the law develops as well. So we almost need to watch the space to see how people react to issues of contribution and causation, as we mentioned earlier, because it could well, if for example, they take the approach of saying it's a more strict liability because this is a high risk area, then that might well impact on what cover is needed and sort of all the various issues with warranties and indemnities and things like that. So I think it is really a watch this space, but as Amy says, it could be a whole myriad of options.
But it's a very exciting time, isn't it? Coupled with AI, we're certainly in for not necessarily a bumpy ride, but an interesting ride, and both for us as lawyers and also the insurance fest that might suddenly transpire with all these new products that need to be insured. Well, we've run out of time, unfortunately, so I'm going to pass the baton back to you, Sarah, if I may, to wrap up. Thank you.
Yeah, great. Thanks, Harriet. So thanks, everybody, for joining us. A recording of the webinar will follow, so please do feel free to share it with anybody that you think might be interested. If you do have any questions, if you go away and think of any, please do get in touch with Amy or myself, and we're more than happy to chat further. You'll get a feedback form at the end when we sign off. If you can, please take the time to complete that. We'd really appreciate it. And make sure you do mention any topics that you'd like us to cover going forwards. The sun has finally arrived in Manchester, where I'm sitting, and we take a break for August to try and enjoy some of that. And our next session is the 19th of September, when we're going to be looking at the impact of AI. More details will follow, and we hope you'll be able to join us then. For now, thank you very much. Enjoy the rest of the sunshine, and we'll see you soon.